Welcome everybody as we get started. We're just waiting for everybody to join and we're going to broadcast live on Facebook. There we go. You're at Ethical Issues and Representing Survivors of Human Trafficking and Domestic Violence, Part 2. Welcome, everybody. We're just waiting for everybody to join us here today. Thank you for being here. Welcome, everybody. You're at Ethical Issues and Representing Survivors of Human Trafficking and Domestic Violence, Part 2. We want to welcome you to our CLE. You can see here I've got the Texas State Bar course number, California State Bar provider number, and this is 2 hours of CLE ethics credit. So these are the numbers you need to know to report. This is part 2 of the series. Part 1 was held last Friday at noon. If you would like to go back and view it, it was on Facebook and it's also on Lone Star Justice Alliance's YouTube channel. You can find that recording, the State Bar course number there. If you have any questions, you can email me and I will get you the information. Let's go ahead and get started. So today's agenda, I'm going to be covering initiating representation with your client. My name is Stephanie Trevino. I'm the General Counsel at Lone Star Justice Alliance. Next up, we will have Emily LeBlanc. She's the Chief Program Officer of CASA at Travis County, followed by Mitigation Investigation by Connie Beckerly. She's the Mitigation Investigator at Lone Star Justice Alliance. Then we have Elizabeth Henneke, the Executive Director of Lone Star Justice Alliance, presenting on witness interviewing, followed by Expert Reports by Gina Longwitz, the Professor and Director of the Domestic Violence Clinic at the University of Texas School of Law. And last, we will have a call to action by Allison Franklin, the Director of the CARES Program at SAFE Alliance. Thank you all for being here, and thank you to our panelists. So the Survivors Project began with and has grown to include several of our partners. You can see some of their logos here. We want to thank them for partnering with us, and we really want to thank the law firms Greenberg Traurig and DLA Piper, who have reached out to encourage their attorneys to be pro bono attorneys on this project. That is extremely powerful to have their support through this and to be encouraging their attorneys to do pro bono work. So thank you to them, and thank you so much to all of our partners through this project. So first here, I wanted to give you a little bit of background about the Survivors Project. The Survivors Project began after some legislation didn't get signed into law, but the governor decided to create a customized clemency application for survivors in February of 2020 of this year. This application includes a section that affords the applicant the opportunity to provide a statement to the Board of Pardons and Paroles about their human trafficking and domestic violence victimization. This is really important because it recognized that victims often go down a path that their offenses entrap them in a vicious cycle of abuse and associated crime. We are very thrilled that they are recognizing this and that they want to provide this way for survivors to be granted a pardon. So this clemency application is specifically for a pardon, and a pardon is the use of executive power to forgive a person charged with a crime or convicted of a crime, thus preventing any prosecution and removing any remaining penalties or punishments and all collateral consequences. And because of that, the survivors that are looking for a job application, maybe housing applications, if they are able to be granted a pardon, this would all be wiped from their record, and they will not have that following them around as they, again, jobs, housing, any of those. So we really feel like this could impact their lives in amazing ways. So thank you for being here. Thank you for wanting to help these survivors. Next, our CLE last week went into human trafficking and domestic violence in detail, but in case you didn't see it, I wanted to just touch on what they are before we get started here. Department of Justice defines domestic violence as a pattern of abusive behavior in any relationship that is used by one partner to gain or maintain power and control over another intimate partner. Human trafficking, or trafficking in persons, is a violent crime that involves exploiting a person for labor, services, or commercial sex. And domestic violence and human trafficking can really be tied together. And so that's why we're really glad that the governor in this pardon application, it's not just human trafficking, it's also domestic violence, and they will be able to be pardoned for their crimes that were intertwined with either of those. Domestic violence can really impact a person's self-esteem, and traffickers frequently exploit the already lowered self-esteem to so that victims to continue that relationship. We want to help them through this process, and we are glad you are here. We are going to cover a few of the model rules of professional conduct with that in mind, who the clients are. So this is Rule 1.2, and this is the representation and allocation of authority between the client and the lawyer. So in this case, your client will be a survivor, and I believe that will color your relationship with them in ways that you can be concerned with their well-being and keep up with them. And we know some of you here are criminal defense attorneys, and some of you may be involved in completely other parts of the law. You and may not have individual clients, but this is a different type of representation, and there will involve communication with your client and just really engaging with them. Go here to the next slide. This one continues the client-lawyer relationship and really deals with the communication. So a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. So I wanted to just discuss here that the survivor may want to know what they need for their application. They'll need you to be very clear and communicative about what is needed to complete the application. They will need letters of support, and we will go into all the details in forms that we will provide to pro bono attorneys, but we wanted to make sure that you keep up with them, what's needed, when their application's turned in, if it's been reviewed by the Board of Pardon and Paroles, and what the outcome is. Just be sure to be communicative with your client as we go through. If you have any questions, Lone Star Justice Alliance and the Survivors Project is here to help you answer your client's questions. to provide you with forms. We want to make this easy on the pro bono attorneys to help these clients seek their pardon. So next, I want to get into the forms here. So this is the first form that we have that is actually for survivors to fill out. So this form is housed on Lone Star Justice Alliance's website. This is correct, it's under Our Work Survivors Project, and we are sending survivors here to fill out this form first and foremost so that we can collect information and begin to match them with pro bono attorneys that are interested in providing counsel for them. So as you fill out the pro bono attorney form, and if you have any specific requests, we can do our best to match you with a survivor that would be the best match for you. So this is the beginning of that form. And the pro bono attorney form is also housed on Lone Star Justice Alliance's website if you're looking for that. And I believe it's included in a link in the email to you also for attending the CLE. If you're watching this CLE on Facebook or on YouTube and you don't see that, then please reach out to me for that information. Next, this is the pro bono attorney agreement. So when you agree to take a case, we will first give this over to you so that you know who your client is, fill out information with them that will help you to begin that relationship. Again, we don't want to leave you out. We want to be able to give you as much information as possible and assure you that there are forms to create this relationship. Next, we have one other form here, and this is the release. This is going to be given to the pro bono attorneys. So all of these forms will be given out to the pro bono attorneys once you sign up to be a pro bono attorney for the Survivors Project. So we really appreciate your support. It is amazing what this can accomplish for survivors. Had one other statistic here that I had over 27 million people worldwide are affected by human trafficking and domestic violence, and less than 1% are identified and protected. And this really gives those people the protection that they are seeking in a way that will follow them after. Obviously not before, but this is later from their convictions. Thank you all so much. I am going to go ahead and pass it on to Emily LeBlanc that will be covering trauma-informed interviewing. Thank you all.
Hello, thank you for having me. I'm Emily LeBlanc. I'm the Chief Program Officer at CASA of Travis County and have spent most of my career as a trauma therapist and then running programs for our local rape crisis center and domestic violence shelter, and now here at CASA. So I'm excited to be here and talk to you a little bit about how to interview survivors of trauma. First of all, let's talk about what trauma-informed really means. It means two things. First of all, understanding the effects that trauma has on victims, but also committing to not re-traumatizing the victims in your own interactions. So why should attorneys and advocates bother with that? Well, first of all, to be kind and to be a good human. Hopefully we're all in this work to help, and certainly understanding the impact that trauma has on victims and committing not to further that trauma is an important part of that. But it also drives, what's in your client's best interest. If you're client driven, you want to do what's in your client's best interest. And being trauma-informed, approaching interviewing through a trauma-informed lens will help you get more and better information from your client so that you can make a better case. Your victim will be a better witness. They'll be more willing to assist and answer your questions and really be an ally for you in their own case. Talking about trauma in 30 minutes is no easy feat, so I would encourage all of you to seek out and learn more about trauma and the effect that it has on victims, specifically about their memory. There's lots of great webinars. I would point you to, for example, End Violence Against Women International has lots of training online that you can view. Rebecca Campbell has some great webinars specifically about how trauma affects memory. Because we certainly can't get through all of it today in 30 minutes. So please seek out some additional information because it will be helpful in how you interact with victims. But what you need to know basically about how trauma affects memory is that when we experience fear or terror or a traumatic incident, memory gets stored in a different part of our brain. It's not the same part of our brain that can tell you, what I ate for breakfast, what I did yesterday. It's not the part of my brain that makes sense of things or that tells stories. It's not linear, it's not time specific, and it's not in a story form. So when we're asking people to tell us about the worst things that have happened to them, that can be really difficult because it's not stored in their brain in a way that really makes sense to us or to them. Traumatic memories are largely sensory. So it's really common when you experience fear or terror or a traumatic episode to remember how things smelled, for instance, or how they tasted or specific sounds, especially smells. And you can understand how that helps keep us alive, right? So think about the last time you cut open a rotten apple. That smell, you may not remember ever eating a rotten apple, but it is literally in your DNA that if you smell a rotten apple, not to eat it because it could threaten your life. So those are really deep-seated memories and largely sensory. We also store a lot of memory as emotion during a trauma. So it's common for survivors to remember how they felt even if they can't tell you exactly what happened in a way that makes sense to you. One of the best representations or kind of analogies for traumatic memory that I've heard came from Rebecca Campbell. So she talks about, if you're sitting here taking notes about what I'm talking about right now, you might have a legal pad, you might have a Sharpie, and you're taking, pretty detailed notes about what I'm saying. And if, at the end of our 30 minutes, I asked you to then kind of retell me everything that I said in that 30 minutes, you could probably do a pretty decent job. You could in order, you could hit the highlights, you'd have decent notes. The comparable memory, if you were in fear or experiencing trauma, would be if I handed you a sticky pad note and asked you to write on the sticky pad as much as you could about what I was saying, and then took all of those sticky notes away from you, threw them up in the air, let them land on the floor wherever they may, and ask you to recreate the speech that I gave. So, it's not that the memories aren't there, they're just fragmented, so you couldn't get nearly as much information on every sticky note, and they wouldn't be in order, and they wouldn't necessarily make sense to someone who hadn't been the one taking the notes. So what happens when we sleep is that our brains try to make sense of all of those sensory memories and pull them into the part of our brain that does make sense of things, because we as humans like to make sense of things. We like to be able to put things in story form and in a linear form. And so sleep helps us with that and helps us kind of put things in the filing cabinet of our memory. But what makes something traumatic is that it doesn't fit into the filing cabinet, right? So you don't have a file for whatever it was that happened to you that was traumatic, that threatened your life. And so those memories remain in traumatic form. They stay as senses or as feelings. That's important for you as the attorney because those types of memories can help you get the information that you need. Your client may not be able to tell you a story in linear form, or at least a consistent story of first this happened and then this happened and then that happened. But they might be able to tell you what they smelled or what they heard or how they felt at the time. And those can be kind of keys to unlock the information that you're looking for. Dr. David Lisak, who's another trauma expert, would say that you should let the symptoms tell the story. the symptoms or evidence themselves that the trauma occurred. So they can be really instrumental in helping you get the information you need from whatever client you're interviewing. So specifically about interviewing victims and survivors, start with questions that they know the answer to and that matter to them. So those questions can ground the victim and really prime the pump of their memory, and it can also help you build rapport. So start easy and start with things that they're going to be able to answer and that you know they'll be able to answer, and then move to broad general questions like, tell me what happened that night. Listen for language cues and drill down. So remember that victims don't know what's important to you. This is really important anytime you're asking a victim to tell you about their story or about traumatic things that have happened to them. What you think is important may not be the same thing that they think is important. They're not trained in law enforcement. They're not attorneys, so they don't know what's important to go on their application or to go into their case until you tell them. So listen for language clues, and when you need to ask more questions, do that. Don't assume that they've told you everything that you need to know. And ask them about how they felt or what they heard or what they smelled. Smell can be a particularly strong memory during a trauma and can be a key to opening up other memories about that experience. So let's talk for a minute about what I mean by language clues. Look first for language that minimizes. So for example, if you say, did he hit you? And the response is not really. That's a minimizing response, right? She didn't say no, she said not really. So that gives you a clue that might be something you want to ask more about. Did you feel pain? And the response is not much. Again, that's not a no, but it's minimizing language that you might want to explore a little further. Look for gaps in physical place. So remember when memory's fragmented during a trauma, fragmented memory retrieval would create jumps from one moment to another. So things aren't in order in the survivor's brain. You can catch that by catching changes in physical location at the scene. So for example, if she says, he was shaking me and I banged into the refrigerator and then I fell by the couch and hit my head. You might want to follow up on that. How did you feel when you went from the kitchen to the living room? So pick up on those jumps and gaps in physical place as she's telling you her story. Or ask, what were you thinking when you went from the kitchen to the living room? Listen for who is the doer, knowing that victims may use a passive voice or use I to take responsibility away from the batterer. So for example, she might say the gun went off. You might follow up with, what were you feeling right before the gun went off? Or she might say, I lost my balance and fell into the table. And you might follow up with, do you remember what was happening when you lost your balance or what you were thinking right then? So she might instinctively try to take responsibility or try to minimize the batterer's behavior. Victims will often skip the worst part, and that will lead them to lose whole chunks of time. So for example, if a survivor were to tell you the story that morning, my batterer thought I'd been cheating. He wouldn't let me go to work. There was just all this yelling and name calling. I was scared. At some point, I was just begging him to let me go get the kids from school. And that's when it finally ended. Bring that survivor back around to the lapsed time by asking general grounding questions like, did you and Taylor stay home the whole day? What was going on with Taylor while the kids were at school? What about Taylor scared you that day? You may have to ask questions multiple ways using different kinds of language. Try as hard as you can to use behavioral questions rather than words like rape or batter. Be calm and non-judgmental as much as you can. Listen to what the client is saying and accept their responses. So a common mistake we make when we work with survivors sometimes is thinking that we know better than they do what they need or what they want, or that all survivors have the same experience, and what happened with the last person I talked to must be the same thing that happened with this survivor. It's really important that you accept the response that the survivor is giving you, and if you're not getting the right information, ask the question in a different way. Ask open-ended questions when you interview survivors. So things like, tell me about that, or how did you feel then? Use neutral language like your ex-boyfriend, your husband, your roommate, your partner, your son's father, instead of labeling language like batterer or even survivor. Don't ask why if you can avoid it. Don't say rape if you can avoid it. Put that in behavioral terms. We'll talk more about that in just a second. And avoid as often as you can labeling language. So for example, instead of asking, did he strangle you? Remember, survivors don't know technical legal definitions. Instead, ask, did he put his hands on your neck? And when that happened, could you catch your breath? Same with sexual assault. So instead of saying, has he ever raped you? Particularly in survivors of domestic violence who have been raped by intimate partners, they may not label it as rape or know that it's rape. It would be better to ask that in a behavioral way. So did it ever happen that he wanted to have sex and you said you didn't want to, but he did anyway? Same with physical violence. So instead of has he ever beaten you or have you ever been battered, those are technical terms that survivors may or may not identify with. So instead ask, tell me about a time that he hurt you, or tell me about a time that he really scared you, and then drill down as you get some of those other language clues. Instead of did you call the police, ask were the police called. Again, the survivor may answer just the question that you're asking and not understand, to give you more information unless you ask. So ask as broadly as you can. Remember that trauma reactions can persist long after the event. So in the middle of a trauma, we really only have 4 responses. The part of my brain that's talking to you right now, that's making sense of things, that's analytical, hopefully the part of your brain that's listening right now, you don't have a whole lot of access to in a trauma. And that's for good reason. That's what keeps us alive, right? So if a bear is chasing me, and I stop to think about what's the right response to this, I'm probably going to be dead before I can react. So when we're in fear, particularly in fear for our lives, a part of our brain takes over that's completely subconscious. And we react in a matter of fractions of a second without even knowing that that's what we're doing. And all humans will have generally one of 4 responses: fight, flight, freeze, or appease. Now, appease is a little different than the other 3 because you do have a little more access to your prefrontal cortex during an appease reaction. I think fight, flight, and freeze are pretty self-explanatory. Hopefully you've thought about those before. Fight being literally fighting back, or being verbally aggressive. Flight being both fleeing the scene or actually hiding. Freeze being deer in the headlights, basically. So you'll talk to survivors who, didn't leave the scene, didn't fight back, felt like they were hovering over their body at the time of an assault. That's a freeze response. And appease being, the response of doing whatever you can to get out of that situation. So, if I'm walking to the car and someone points a gun at me and tells me to give them my purse, I'm probably going to throw my purse to that person and say, take my car, take whatever you want, just don't hurt me. That's an appease response. And what's important to know about that is that anything that triggers a memory of that trauma can trigger a similar response. So, and it won't necessarily trigger the same of those 4. So everyone uses fight, flight, freeze, and appease. And any of them can be triggered by something that reminds you of the assault. And that thing that triggers the memory might be you, just asking questions about what happened. And you might do it inadvertently. You may not even know what the triggers are. So it could be a sound, it could be the tapping of a pen, it could be the tone of a voice, it could be the color of a shirt. Anything that triggers those sensory memories might trigger also a trauma response. And what that looks like, years after the fact might be a survivor who tells you exactly what she thinks you want to hear so that she can get out of the conversation. Or a survivor who seems to have emotions that don't match what she's telling you. or seems to have no emotion at all. So she might be in a freeze response if there's no emotion as she's talking about, some of the worst days of her life. She might be really combative and really angry with you. That's a common fight response that you'll hear, forensic nurses talk about or advocates talk about who accompany sexual assault survivors, or law enforcement talk about after the fact, that, people that they're trying to help sometimes seem angry with the people trying to help them. And that's often because, that trauma response has been triggered. Ways that you can avoid that, or at least help mitigate it as it's happening. First of all, give that survivor as much control as you possibly can. And that can be as simple as when you meet, or where they sit in the room, or whether or not the door stays open. Anything you can let them control, you should. Always begin by addressing basic needs. So, are they hungry? Do they need water? Do they need a blanket? Do they need clothes? Make sure as much as you can that their immediate needs are taken care of before you try to dig deep into memories and trauma. Write things down for survivors as much as you possibly can. Remember, memory is not great when you're experiencing trauma. And certainly that's true when you're re-experiencing or trying to tell someone about your experience. So don't think that they're going to remember, that you told them that the application is due tomorrow or that you need a letter by next week. As much as you can, write down everything you need from them and due dates. Start by explaining exactly what they can expect. So remember, survivors don't have a legal background, and some may not have a whole lot of experience, or may not have been, especially if you're talking about clemency, may or may not have had an attorney who explained the whole process to them the first time. So as much as you can, explain what to expect from you and from the system. Offer breaks. Especially if you see some of those fight, flight, or freeze responses. They're common for survivors to experience, but if you get to the point where the survivor is having a hard time tolerating the conversation, it's really important that you offer and build in time for breaks so that she can ground herself and stay present with you and give you the information that you need. Make sure that you're doing whatever safety planning needs to be done. So don't assume that a survivor is safe now, even if she's not currently with the same trader. So ask about what her safety needs might be and make sure she has appropriate referrals to people who can help her with that. Learn to differentiate lying from trauma. So that's part of why I would encourage you to seek out more extensive training on trauma, because lying and recalling traumatic experiences can look a lot alike. And particularly law enforcement can get really confused because they're trained really well to tell when people are lying. And sometimes it looks exactly the same when someone's experienced trauma. So learn to tell the difference between those two and ask yourself, could this be a symptom of trauma that I'm seeing if you start to think someone's not being honest with you? Reiterate as often as you can that you believe the survivor and that it's not their fault what happened to them. Make sure that you're holding space for and normalizing emotions for them, whatever they may be. And the emotions that they're expressing may or may not match what you think they should be expressing. So it is not uncommon for survivors to laugh as they're talking about their experience, or to seem angry, or to seem emotionless. All of those are perfectly natural trauma responses. And it's important that we normalize that and not judge, why is she laughing about this? This is a good one for both, attorneys and advocates, but, even anyone out there who has children, use your nervous system to calm theirs. As much as you can, keep your nervous system calm, and just being a calm presence in the room can sometimes help calm the people with you. So that can be the survivor that you're working with, or if you're a parent, it could be your own kids. Remember that the survivor is the expert on herself. So again, don't assume no matter how many survivors you've worked with, that you know what's best for her or that you know what she needs. Every single survivor has different needs, and she's the expert on what that is. Remember that survivors aren't all the same. So their wants and needs are going to differ, and they're not all going to present the same way. And we're not going to like every single person that we work with, and that's okay. We can help someone whether we like them or not. So don't assume, no matter how much training and experience you have, that you'll know what that particular survivor wants or needs when you walk into the room. Remember as much as you can that it's not about you. So no matter what her reaction is, if she gets angry with you, if she's frustrated with you, if she's detached from you, that's probably not about you. In your relationship with that survivor, it might very well be about what she's experienced. So remember as much as you can that it's not about you, it's about her and what she needs in order to be okay and to heal, and try not to take any of her reactions personally. And finally, take care of yourself. So you can't show up and be present for people who have experienced their own trauma if you haven't taken care of your own. And hearing traumatic stories all day, every day can take a toll on all of us. So make sure you're taking care of yourself, especially amidst a global pandemic. We're all experiencing a collective trauma right now. So to the extent that you need to, make sure you're taking care of yourself and that you really are grounded yourself before you walk into a room with a survivor or start an interaction with a survivor, so that you can really use your own nervous system to help ground her and to get what you need through that interview. So I'm opening the chat now because I saw a few pop up. So I'm sorry I ignored you when it happened because I didn't see it. Talking points in writing. I can send some to Stephanie. I will admit that I am pinch hitting for someone who was supposed to be here today and had a last minute loss in her family and needed to go take care of her family members. So I don't have a formal presentation for you, but I can certainly put my notes together and send that to Stephanie so that you have the high points of what we talked about. In the midst of the pandemic. Yeah, the pandemic makes things really hard because you don't have all the same tools of assessment that you would in the room with someone. So I would suggest that you pay attention as much as you can to what you can see behind them. So especially if a survivor is in a home, for example, don't assume that they're safe. Make sure, before you get into really detailed information, that you know who else is on the other end of that Zoom. And come up with a way to talk to that survivor if they need a code word, that if they say the word, cheese pizza, you're going to stop talking. Talk about how to safety plan around being on Zoom before you get too far into the interview. And you might have to use lots more verbal cues than you would in person. So you're not going to be able to see if her foot is tapping and she's getting agitated the same way as if you were in a room with her. So you might have to stop more often and ask, how are you doing? Are you okay? Let's take a break. And as much as possible, help her with grounding. So if she's starting to really feel agitated or experience some fight or flight responses, simple grounding techniques can be, are your feet on the floor? Put your feet on the floor. Let's take some deep breaths together. Or look around the room that you're in and tell me every color that you see. Let's name sports teams together. You start with A, we'll go through the alphabet, see if we can think of one for every letter of the alphabet. So anything that kind of turns that prefrontal cortex part of our brain back on will help ground us. Simple math problems even can help turn that part of our brain back on so that we don't go too far into fight, flight, or freeze. So you may have to do more of that verbally via Zoom than you would if you were able to be together. Are there any other questions? If not, then I will turn it back over to whoever's next.
Hello, good morning and afternoon to everyone. I am Connie Beckerly. As Stephanie introduced earlier, I'm Connie Beckerly with LSJA. I'm going to go ahead and put my slideshow up and talk along through it, but I wanted you all to see my face. Hello, here I am before I get going with that. Okay, you guys should be seeing my, maybe not. Please pardon my technical difficulties. Tech is not my strong suit and it is being mean to me lately. Okay, mitigation, new techniques to employ and consider. It's very possible some of you have heard of mitigation. It is also possible that you've heard the word and heard it in conjunction with the legal field, but don't know fully what it means, what is required, what you can do, the powers and privileges actually that we are afforded that allow us to do mitigation investigation. So I'm going to talk to you a little bit more about that right after I do a little bit more about me. I come to you as a survivor myself of assault and sexual abuse and neglect as a child. I was actually in the Child Protective Services foster care system, and I am now I now have a Master's of Social Work and a JD. I spent about a decade, at least it feels like it, I round up a bit, working for CPS, and I then went into medical social work and eventually into law. Done a number of other things along the way, and I have so many fabulous examples of mitigation that I could give. But before I do any of that, let me go through some just basics. I presume we all know here, but obviously we are to rely on best practice. We want to rely upon the guidelines. And as you can see here, there are a number of good sources to find out what those guidelines are. One I'm going to point you to specifically is the sentencing campaign. Whoops. That's a particularly good one for youth justice, which all of these survivors that we're talking about here either were youth or are youth during the times of the crimes. All right, I'm moving on to the actual standards. Here we have the ABA standards for criminal justice. I won't read, goodness. I won't read the entire thing. I want to highlight a couple of points. The duty aspect, that's one thing that we as employees in the legal field or in the social work field, any social service field, we know that we are there because not just we want to be, but because there's an obligation. That's what we sign on for when we do these kind of jobs. I think that it's very easy to get busy in this field and end up not fully investigating, not fully doing the full due diligence. So these next few slides are just a few more reminders of that requirement for due diligence. The law actually does require, there is a duty to investigate. Wiggins versus Smith and Rompilla versus Beard, if you get into this line of actual work, you may find more about these cases. You may see these repeated. These are the cases that we would reference when asking a judge to appoint a mitigation expert, for example. There is a duty to appoint. there is a duty to appoint appropriate experts, including mitigation investigators. That duty is found primarily starts with Akey versus Oklahoma. And proceeding from there, there's the Rumpilla versus Beard. As you can see, we have adopted the ABA guidelines. So we'll get you guys a copy of these slides, I believe, but you can look back through and obviously do your own research, but there is precedent to appoint mitigation investigators, and beyond precedent, there is a requirement to investigate using the top line professionals that are accessible to us, and a duty to find them, a duty to make sure that investigation is completed. This slide talks about pretty much what I'm saying here, the zealously investigate, be here on this slide. Zealously, what does that really mean? We all know what it means, and it's easier said than done, but do we do it? Do we actually hire a person who's got the skill set, like Emily just was talking about, and like Emily herself, a person who knows how to get into the details of this client's life so that we can actually use all of the information available to us to make the best possible case for the client. Counsel should investigate the allegations. Goodness, keep trying to move my slide because y'all's little pictures, some of our pictures are in my way on these slides. You get the idea. Everyone understands these basic principles if you're where you are as a professional. So I don't need to beat that into anyone or pardon the bad choice of phrase. I don't need to go on and on about it, but I am, because people need to hear it. We need to be reminded. I think every day, especially when we're dealing with crises like the pandemic in our own personal lives, it's important to remind ourselves that we did commit to a job and we are professionally bound to do the full job. So the implications of those ABA requirements and those case law requirements, they imply the necessity of complete discovery. They imply that we must obtain a criminal history, that we must request law enforcement records, and we must fully collect documents so that we can give the client, in this case, hopefully you guys will take a case, and in this case, it will be a domestic violence and/or human trafficking client. We want to do the very best job we can to investigate and show that this person was a victim, not a criminal, not a complicit individual. Next slide. Mitigation is the process of humanizing a petitioner through fact-based storytelling. Again, this harkens back to what Emily said. The more facts that we can get the victim or client to tell us, the more we are able to complete a story in our own head and a case plan to go forward with defending, if necessary, and advocating for, in whatever way, these victims. Here we have, I'm sure everyone remembers this, unless you were fortunate enough to be off the internet for a while during this moment in social and cultural history here. The dress. Why do we investigate rather than relying on information presented by, say, law enforcement or even professionals like, for example, Child Protective Services? That's one entity that is often involved in juvenile cases. Though the information coming from the investigatory entity that had the case before us or was involved with it alongside us may be accurate with quotes around it, it might not be the full story. And perspective is, I want to say, everything. Clearly it's not everything, but it can make or break a case. I think most of us know that too. This is the reminder. Here's a good visual. Put this picture up if necessary in your office or in your home. One person sees one thing one way, one person sees something another way, and it can be, both sides might be accurate, but what do we want to do? We want to present our victim's side. We want to present their story. We want to explain why their version, quote, of events is the one that the judge or whoever we are advocating to listens to. All right, moving on to records, and I hope that you guys are with me. Again, we will take questions at the end, so pardon me if I'm jumping too fast over things, but we're going to look at some records that it's critical to try to collect for every case, for these specific cases, and really I would say for any case involving a juvenile or a person whose history involves the possibility of involvement with the entities that are listed here. We're going to want school records. School records tell us so many things. They tell us if there's a disciplinary report at the school or multiple disciplinary reports. They tell us if there are favorable reports. They tell us the grades, obviously, and we can interpret a lot from that information. We can't assume from it, but we can interpret and then proceed with the investigation, determining if those particular things that we glean from those records are actually relevant to our victim and to our case. It may be that the victim was a straight A student. It may be that that allows, that can be an argument point to the contrary of someone saying, this is a slacker, this is a person who wasn't trustworthy, who didn't do what she was asked to do. Why should we believe her now? It can something as simple as grades can work for you in a case. Hospital and medical provider records. Some of our victims have, a lot of our victims have physical injuries. There may be rape kits. There may be other sexual assault exams. Then again, there may not be. And this is another place where we have to do due diligence. Just because there's not a rape kit or whatever doesn't mean that we don't look for other medical records. There may be other clues. What if the victim was diagnosed with a venereal disease, for example, but claims to have never had voluntary sexual intercourse? Well, that's a huge thing that's a huge discovery. Then you track down, is this a lying child? Usually not, and that's backed up by stats. And I can get you those if you want. But usually these folks are not lying, and you get my example. Mental health records, I'm spending a lot of time on this slide, so I'm going to go a little faster down this one. Again, you probably have read ahead on these. Mental health and social service records, and really all of these, the same kind of thing. You're going to find different perspectives. You're going to potentially find witnesses who can speak to the validity or reliability of your client. You're going to find sometimes cross information, things that conflict. And if you trace that all the way back, sometimes you can find things that you can use as part of your argument to support your victim. There's some more noteworthy records that we don't always think about, especially maybe if you're not in criminal defense. Family photographs. You can tell so much from a family photograph. Again, we can't assume, but the very existence of family photographs or lack thereof tells you something. If they don't have many, does it mean they weren't close to their family? Does it mean they just didn't want to be in pictures? Does it mean they didn't have a digital camera? Does it mean they don't know how to take pictures? Could be lots of reasons, but it's something to investigate. Clearly, if the person isn't close to their family, that's something to dig down into deeper. Same for the pictures of the home environment and any video. You're going to get a better sense, and videos even better, of what a snapshot or a snippet of real life was like for your victim. You can see, was the home in disarray? Was it obvious that possibly somebody lived there that was angry and threw things? That's probably unlikely to be in a photo, but you just never know. It's worth tracking down everything you can get. And with cases of kids that were abused and were in the quote system, CPS is going to be a good source for some of that. And you can often tell, you can't assume neglect, but you can tell from the home environment if there was general care given in the home. Again, anything that supports your victim's statements regarding the abuse and neglect is going to be important for your case. Correspondence, especially children's correspondence, that's critical as well. Again, even more than online, digital. These days, we all know to go look at someone's Facebook page, but an actual private correspondence thread, say in an email or maybe even handwritten, especially if your client has been incarcerated, those letters can tell you much more than, or at least tell you more about a separate part of the client's life than can a social profile. People don't post on Facebook and Instagram necessarily the things they don't want people to know, like that they're being abused. There may be some clues there, and there may be some genuinely good information there, but track down individual correspondence, not just social media correspondence, if you can. Artwork, poetry, prose, anything written by your victim. As Emily referenced, you're gonna glean things from the victim when you get things from the victim in their own words. And when you look at their poetry or written work of any kind or art, again, don't assume, but you can collect it and use it. You can go back to your client victim and just ask, what did this mean to you? Tell me about this. It may be that it meant nothing and it was a doodle or some silly words that they felt like writing while bored. It might be that really what this artwork or poetry was speaking was a personal record of the abuse. And that can be extremely valuable, both in presenting a narrative that showcases your client's perspective and also in understanding your client, which you really do need to do. You need to understand the psychology of your client as best you can, even though that's not our field in the legal field. But it helps. It helps understand, like what Emily was talking about, things like why might a client lie? Why might a client give you a discrepancy answer as opposed to what they gave, a different answer, excuse me, than what they gave to another professional. Okay, juvenile records, unique challenges, and there are some. We find a lot that records have been destroyed depending on how old your victim is and how long ago the abuse occurred or whatever you're looking into occurred. Some entities like Child Protective Services will have requirements that they maintain documents for, say, 10 years. Lately, as in the last 10 years, those requirements have been changing. They've been becoming more strict because we're more able to digitally record and keep records. But there are still times you're going to encounter, in all likelihood, that the records have been destroyed, or that at least you're told that they have been, that they're not able to be found, which is my second point. They may no longer be in the possession of the agency. It's possible, say, for example, I use CPS as an example a lot, but CPS may have destroyed the records, but someone else may have a copy. The client themselves may have a copy. The juvenile justice system, probation, the court, any other investigative entity, or basically any agency could have these same records, because oftentimes these agencies, social service agencies, share records just like legal professionals do. So we want to look for all records. If somebody tells you the records are destroyed, persistence, my et cetera down there is for persistence. I'm going to get there. But we want to push politely and try to get them to go on the record, get an email, get something from them saying, hey, I looked, I'm so-and-so, and I looked, they're not here. If the records really are not there, then try those other agencies. The next big one is records protected by confidentiality. Of course, we have so many confidentiality rules for such good reason, and those are especially critical when it comes to juveniles. It's not a juvenile's responsibility to make a decision as a juvenile regarding things that have happened to them being public. A juvenile doesn't get to say, and we know this, yes, so-and-so, you can see my records. Yes, I don't mind if you read everything about the horrible incident, the trauma that occurred in my life. That's not up to a juvenile. Once the juvenile becomes an adult, of course, he or she can sign a release. And when we have releases, oftentimes we are able to get records. Sometimes even then, some entities push back, or they don't accept, excuse me, the type of release that we send. You may have to go back and forth with them on that. If they come back absolutely insisting that there's a confidentiality restriction we can't get around, or for some reason we can't get a release, but we have the legal right to these records, we're going to go to this has been talked about in the news quite some over the last few years, so you probably have at least heard the terms, and you may well know what you can do with these. But the Freedom of Information Act, otherwise known as FOIA, and the Public Information Act, which is Texas's version, the PIA. I'm going to go through these a tiny bit. I'm going to give you a minute to read the slide there. I would like you to actually read the literal language. These both are pulled straight from the websites, and I'm going to go ahead and take us there in a moment. Okay, we are going to Freedom of Information Act. You will see that there are exemptions. You will see there are 9 of them. That's a lot. It can be tricky. The law does say the public has the right to a great deal of government information and other, quote, public information. Again, you can read these closer on your own time, but there are exemptions. They don't have to provide everything, but they do have to provide more than sometimes they want to, I think. I have to find my way back to my slideshow. Here it is. Okay, and then the PIA website looks about the same as far as how they list out. You can click the links to find the exemptions. Let's see, what about confidential information is a good one. This is the super detailed page. And again, I know you guys can all go here later, but this is a critical key to getting some of the information that is otherwise hard to get. It's the law that they have to give it. So will they always? Not necessarily. And that's my other etc. Coming back to that, we just have to be persistent. Don't take no for an answer unless you know it really is a no, and keep going to other agencies and entities and trying to find what you need. You can go back to the client sometimes and find out more places to go for things that we need. Next, we have an example of an actual PIA. This is, whoopsie, this is an email I sent. Dear Attorney General Paxton, on behalf of LSJA, under Chapter 552 of the Texas Government Code, which is the Public Information Act, I am respectfully requesting all disciplinary records regarding our client. And then obviously the name is blocked out, but you can see it's simple, right? Who would have thought? It's super simple. Anyone can send one of these. I did receive, for this example, I received a response back and did not receive all of the records. So we are currently working on that one. Case in point. It's not, there's no guarantee you're going to get everything that's out there, but you're going to get a lot more by going through these channels and avenues. So this next thing is actually a tool you can use. Moving on here, giving you a lot of background. Now we're at the point where we talk about what do we do with all of this information that we gather. We gather. We end up with things with conflicting dates and conflicting date of births and all kinds of things, and we have to make sense of it. This is an example of, or this is a real portion of a real client's timeline. I changed most of the actual details and all of the identifying details, but you can see that we start with birth and we go all the way to the end. You don't go to the end on this slide, and this is just a snippet. In fact, we'll go on to the next one. And that's my last boring slide that looks like this. But the timeline, the point isn't to bog you down with the details that are on it. The point is to demonstrate what it can do. What we want to do to create a timeline is gather all those documents and just start plugging them into an Excel sheet. You can always rearrange later. Put in the date, put in the info, put in where you find it, because sometimes it's hard to find later. I think we probably all know that one. If you're looking for one minute detail, in a big stack of things. So in this client's case, we've got highlighted some pattern information. That's what the glory of a timeline is. Once you get it done, you read through it and you see the patterns, or should see patterns in the client's life. In you guys' case and everyone taking these cases, the pattern isn't going to be things like running from a police officer necessarily. It might be, but it might be a pattern of grades starting to drop, or student began to be absent from school more and there's no medical explanation. Those are the kind of patterns that you might see in a sexual abuse or domestic violence or trauma case. For an adult victim, and if you're working an adult case that was an adult at the time of the incident, or even after going forward from their young adult life, you can check employment records and patterns for the same kind of thing. Were they suddenly not showing up? Did they have a traumatic experience, a re-traumatizing experience because of a memory like Emily was speaking about, and have to take a mental health day from work? Things like that. So the timeline, I hope that I made that clear. It looks super boring, and it isn't, it's not anybody's idea probably of fun unless you really like Excel, but it's worth it because it can make or break your case. If you look through and see patterns and repeating patterns, different patterns, those things are things to focus on, to dig deeper, to investigate more, and to use in your argument. Okay, we are actually to the end, other than my Q&A and one little bit I want to do. My apologies if you've heard this, but I'm going to do it again if you have. And this is my pitch to try to get every single one of you attending today to take at least one pro bono case and to see about this work. It might not be what you signed up for and you might never want to do it again, or it might change your life and you might fall in love with this kind of work. Once upon a time, there was a wise man who used to go to the ocean to do his writing. He had a habit of walking on the beach before he began his work. One day, as he was walking along the shore, he looked down the beach and saw a human figure moving like a dancer. He smiled to himself at the thought of someone who would dance to the day. And so he walked faster to catch up. As he got closer, he noticed that the figure was that of a young man, and that what he was doing was not dancing at all. The young man was reaching down to the shore, picking up small objects and throwing them back into the ocean. He came closer still and called out, "Good morning. May I ask what it is that you are doing?" The young man paused, looked up, and replied, "Throwing starfish into the ocean." "I must ask then, why are you throwing starfish into the ocean?" asked the somewhat startled wise man. To this, the young man replied, "The sun is up and the tide is going out. If I don't throw them in, they'll die." Upon hearing this, the wise man commented, "But young man, do you not realize that there are miles and miles of beach and there are starfish all along every mile? You can't possibly make a difference." At this, the young man bent down, picked up yet another starfish, and threw it into the ocean. As it met the water, he said, "It made a difference to that one." On that note, my Q&A will be at the end, I believe. I didn't see any questions come in. So I will close out and hand this over to Elizabeth, who will be taking over from me to, I should say, the esteemed Elizabeth Henneke, our Executive Director of LSJA.
Great, thank you, Connie. If you can stop sharing your screen, I'll load up mine as well. I love that parable and story, because I think that's exactly right. People always ask our staff, how do you keep going given the seriousness of our work, and it's the wins. So I am excited to transition here. First of all, I just want to give everybody a minute to just stand up, stretch your legs. We've been just throwing trauma at you. We've been throwing records about abuse. We've been throwing all of these things to you. So we're going to take a 5-minute break so that all of you can stretch, you can unwind, take deep breaths, and sort of center yourself back in the moment, because Gina and I have a lot to pack in for this next part of our presentation. But let's take a 5-minute break. I want to give you a chance to stand up and stretch, and then come back, be present in the next moment as we dive back into the next section. So I'll see you in 5 minutes, and go think about how you are going to achieve changing the life of a starfish. Thanks, y'all. All right. I hope everybody got a chance to stretch and sort of get ready for this next portion of our training, where I'm going to talk about witness interviewing. You heard from Emily about how to work and interact with your client. You've heard from Connie how to request documents to start to tell your client's story. And now the question is, how do you round out this investigation so that you can present the best job and the best case to your client as possible? I am really excited because we're going to talk a little bit today about 2 of LSJA's recent wins that we have done in partnership with a criminal defense lawyer up in Tarrant County. And so today is fun for me because I get to talk about some incredible steps forward on behalf of survivors of human trafficking when I talk to you about what we did to put together the stories that have ultimately led to both of these clients being returned home to their families. So I hope you'll be as excited as I am about this portion. Today, we're going to talk about witness interviewing and what sorts of witnesses might be helpful. This is a pardon application. It's not representing someone in court. So how do you put together this narrative, and what witnesses might be most persuasive to the Board of Pardons and Paroles? We're going to talk about the requirement under the application to present letters of recommendation. We'll talk about what's required and our tips of please don't avoid doing these components of preparing letters of recommendation. And then we'll talk about what our best practices and forms of what these letters of recommendations should say. So if you think about it in terms of first identify and interview witnesses, and then move from witness interviews to preparing letters of recommendation that will go within the packet to support the application for parole. I'll take you through it all. So first, why do we conduct interviews? Well, first, the primary objective that you're going to have in most of this is developing the nexus between the underlying crime that led to the conviction you're seeking a pardon for and your client's victimization and their own how their victimization was directly tied to the crime. So I want to be clear that it is not enough. And the Board of Pardons and Paroles has been very kind to give us feedback on how people should prepare these applications. And they have emphasized that it is not enough to simply say our client is a survivor of human trafficking and domestic violence, and our client committed a crime. That will not result in a pardon. You must draw the connection between the client's involvement with this crime that you're seeking the pardon for and their survivorship. And one of the things that Emily did a really good job of, and Connie as well, is telling you about the complexities by which someone's survivorship can lead to their involvement in the criminal justice system. But it is going to be your duty to draw the nexus between the two very clearly in your pardon application. One of the ways that you can do that is through the collection of documents. You can interview your client, but you can also interview witnesses. Second, you want to outline who your client is beyond the one criminal action. So giving context and flushing out all of the facts that surrounded your client when they were involved in the underlying criminal offense will allow the Board of Pardons and Paroles to really understand who your client was, and then at the time of the conviction. Finally, you want to provide a plan for what will happen to your client if they are in fact pardoned. So you want to provide a reentry plan if they're currently incarcerated, or for those non-incarcerated clients, you want to demonstrate what the impact of the pardon will be on your client's life. So this could talk about what their opportunities to have expanded housing. So if there are someone who has to rent and they're unable to rent in certain neighborhoods, be near their family because of the underlying conviction, you're going to conduct witness interviews that will flush that out and give you an opportunity to tell more about how relieving that felony conviction would allow them to live close to family, to receive additional supports, to get a job that they may have a lifelong dream or training to receive, but this felony conviction or even a misdemeanor conviction is preventing them from receiving. The overall goal of providing a plan is to demonstrate to the Board of Pardons and Paroles that society will benefit from this pardon, that this individual, your client, will go on to live a more fulfilling life and be a better community member. So keep that in mind when you're doing witness interviews, that you're wanting to tell a story of what happened in the past, how that was affected your client, and what your client's plan is going forward and how they're going to contribute. One example of doing witness interviews to fill it out is actually a client that we worked with, a wonderful lawyer out of Tarrant County, Scott Brown. I stand in awe of his lawyering skills, and he represented a young juvenile client who attempted to argue at trial that she had been a sex trafficking victim and that her co-defendants in this capital murder were in fact the pimps that were sex trafficking her. And that had been argued at trial, but unfortunately, despite evidence of this, the underlying context had not come through, and honestly the jury just wasn't sympathetic to that argument, and they ultimately convicted her of being a quote ringleader in this capital murder. Again, she did not commit a capital murder, but her alleged John did. So the facts ended up getting quite developed through the appeal as conflicting stories came out from the client herself. And so you had these conflicting stories about what was happening the night of the crime, and you had conflicting stories about who was the ringleader, right? And ultimately, an investigation revealed some records from the Fort Worth Police Department that had been collected prior to the conviction in question. So these are records that were there was already an investigation into whether or not this juvenile was being sex trafficked. And there was evidence about whether or not she was already being severely beaten and assaulted by what would ultimately become her co-defendants. So in this investigation, there were records that were developed that showed the nexus between the conviction and her victimization from police records that were able to demonstrate this. Through the appeal, this client ultimately had her conviction overturned. She was returned, and her life sentence was reduced to 10 years of probation. So that was one that we were able to do through the appellate process, but it would have been a perfect example of a pardon, and maybe a perfect example of a potential pardon now, to release that conviction from her record, because it was clear from these records that she was being the subject of this very extensive trafficking scheme, and that it was her co-defendants who in fact were perpetrating that sex trafficking. And if I can promise you that if someone has the hold and the authority to force you to sell your body for sex, they are similarly going to have the authority to force you to go along with an armed robbery. They're going to have the authority to go forward to ask you to participate in trafficking. And what you'll be able to understand through witness interviews and collection of documents is the complexity of the relationship that underlies those two parties. And you'll be able to prove that nexus between the coercion and duress that someone may be under because of the relationship to their abuser. So who should you interview? Well, my answer is going to be everybody. But ethically, what you're going to want to do is first start with interviewing your client. So you heard talking about interviewing your client in a trauma-informed way. You're going to want to talk to available family, especially those who might be able to, again, address this nexus between the crime and the victimization. If your client has children, they may be able to give context, especially if it's a domestic violence situation and the abuser was potentially the children's father or mother. You want to talk to significant others. This is going to give you information about what the person is like today. You're going to talk to school teachers and counselors, mental health providers. One thing I'm very excited about is that the Lone Star Justice Alliance and our partners in the Survivors Project are working on putting together a list of experts who have offered to provide pro bono services. And you're going to hear a lot more about this from Gina, but we're going to give you that type of support when you're going through this process. So don't worry, you're not out there on your own. We're here to help you. You want to talk to coaches. One thing that's really helpful is to talk to correction officers. So one of our clients, one of our current clemency clients, we've been able to get testimonies from corrections officers who will say, it is clear that this young woman was trafficked and she does not belong in prison. That is extraordinarily helpful. And I'm going to talk to you a little bit about a case in which our client is on path to release because someone from the agency, the correctional institution, came forward and said, this girl is different. The experience and the trauma that brought her here is horrific, and this is a travesty of justice. So please reach out to those who either were part of the correctional institution that held your client or currently, because they may be your best advocates. Oftentimes they can tell the difference between someone who is there because of their own victimization or because they were ringleaders in a crime. And they may be your best evidence for the Board of Pardons and Paroles. You want to talk to ministers, rabbis, other faith leaders, any role models. You'll find that often if your client has been in prison for a period of time, they may have developed a strong relationship with a role model who's guiding them through the process. Those can be great letters of recommendation, letters that will support the release. Talk to employers. That's going to give you great information about that reentry plan. Coworkers, fellow inmates. One of our partners in the Survivors Project is Truth Be Told. Truth Be Told is a organization that goes within prisons and works with women to tell their stories, to give voice to their own victimization. Those women develop strong relationships with one another, and they may be incredibly important sources of information for you as you go forward. Finally, you want to look at community leaders or foster parents. In a case in which we're waiting for our client to be released, we have the support of congressmen who came in and reviewed the facts and ultimately called upon the Board of Pardons and Paroles to do right by this client. And you may be surprised at who in the community is dedicated to supporting your client. So be sure to think outside the box, because having influential community leaders who say we want that person in our community, we want them to receive a pardon and remove that scarlet letter of a conviction, can be incredibly persuasive. And finally, foster parents, and these are not only foster parents in the traditional sense, like Connie mentioned, those who went through CPS, but it can also include just those persons who decide to adopt an individual. For our client who are waiting to come back now, she is a very strong, influential woman who has decided to adopt her and provide her a home and a safe space to recover from her victimization upon her release. After you do interviews, you're going to go back to the drawing board. You're going to put their information into a timeline, and you're going to determine whether or not the person who you interviewed would be appropriate to write a letter of recommendation. So it is required under the application to provide 3 letters of recommendation from non-family members. Now, this may be challenging in your case, depending on what kinds of support that your your client has. So, but you're going to want to be creative about who might be able to provide a letter of recommendation. And again, please reach out to LSJA or members of the Survivors Project to help you think through this if you have any questions. Those letters must say, I support a pardon for the individual. It is important to the Board of Pardons and Paroles that they understand in the recommendation that the person who is writing the letter understands that this is a pardon that will be provided. The board will not look kindly upon any letter that misrepresents the relief being sought, and they'll be concerned that the letter writer doesn't understand the relief they're requesting. So please make sure that the letter writer understands that a pardon is what's being requested and the implications for that. They should also indicate in the letter that the letter writer understands that the pardon is related to the individual's prior history of sex trafficking or domestic violence. Make sure that they are able in the letter of recommendation to tie, again, the nexus between the crime and the victimization. There's 3 critical don'ts as well. So first of all, do not rehash whether the applicant should have been convicted of the crime in the first place. Well-intentioned supporters will often come forward and want to discuss the injustice that led to the individual from being there in the first place. This is not the appropriate forum for that to be discussed. The Board of Pardons and Paroles cannot right the wrong of prior convictions. What they can do is remove the collateral consequences and potentially free your client. So make sure you're not rehashing whether or not someone should have been convicted in the first place. Second, your letter writer should never make representations of facts that are outside their personal knowledge. You want to be really careful that your letter writer has credibility to the Board of Pardons and Paroles, and they're recounting with specificity where they're getting the information. I'm going to encourage you to have them rely upon any facts that they can get that are not from your client, but in fact are facts that they've been able to observe personally or seek from third parties. Finally, you want to make sure that the letter writer does not make promises that the letter writer does not intend to keep. So if a letter writer says in the letter, I am going to provide this person a job, you should confirm that that is in fact the intent of the letter writer, because what you don't want is in a few months later when the application for the pardon gets presented for the board to reach out to that letter writer and the letter writer say, oh no, I didn't really mean that. Right? That reduces your credibility, it reduces the credibility of your client, and it will fundamentally threaten the entire application. I've included here an example of a letter of recommendation that we were able to provide, and I love this letter. It is essentially best practice in letter writing. And it just so happened that this was an incredible supporter who came forward and introduced herself and put it forward her bona fides, her credentials as to why she should be able to provide information that would be relevant to the board. So in this case, this was someone who worked with an organization that specialized in supporting survivors of human trafficking. And in fact, had worked closely with Cecilia Abbott and had worked closely doing national trainings and seminars. So ideal letter starts with, here's who I am and my connection to this work. Second, the person then provided information about her long-standing relationship to the applicant. She indicated that she'd known the applicant for over 3 years, that she was involved with the applicant, but so was her whole family, and that she understood the past history of trafficking and trauma that had been a part of this client's background. Next, the letter writer indicated how they were going to support this person when they were released. So she was able to say, we're going to provide financial and emotional support. My favorite line is when she said, we agree to provide medical, dental, and vision insurance so that this client can access comprehensive mental health care, that they were going to provide out-of-pocket costs to address their underlying trauma. And they were going to, in fact, prepare for a job for this very traumatized teenager to be able to be successful long-term. So I want to set expectations. It is not often you will have such a powerful advocate for your client, but I encourage you when you're doing these witness interviews to really probe into what the individual writing the letter is prepared to do for your client, because as much as you can provide, you'll really want to. And I appreciate one of our attendees has asked the question, is this typical letter of recommendation? No, it's not. This is an exceptional letter of recommendation, but I do think having a full page letter of recommendation that tries to go through this is ideal, right? So not often, but ideal. Finally, you want to make sure that when you're writing the cover letter, you'll recall that Gina talked last time about preparing a parole packet. She talked about writing a cover letter. Ideally, your cover letter will reference these letters of recommendation and put them in the context of the broader investigation that you have provided. So you're going to be relying upon documents that have collected as well as letters of recommendation. And then your cover letter is going to summarize all these components together so that the board has within 1 or 2 pages max sort of the top hits, an executive summary, if you will, of the items that are then attached as exhibits to the letter. This will make the Board of Pardons and Parole's job much easier, and the more that you can make their job easier, the more likely it is that your client's going to get relief. With that, I think we'll end this portion of the witness interviewing. Overall, what you're getting from this entire presentation is just steps that you can do to fully prepare your client's case and the levels of investigation. We are very excited about this project because most individuals could never provide and never obtain the types of packets that we can provide through the application. But remember that what our goal is to give these individuals, these applicants, our clients, a new shot at life, and that this level of preparation could fundamentally change their entire life. So I thank you so much for the time that you've already given through these trainings and look forward to partnering with you going forward. And now to your next speaker, who is your next 2 speakers are by far what you've been waiting for. I'll turn it over to Gina.
Thank you, Elizabeth. And I figure most of you were in part 1 of the training last Friday, but just in case you weren't, my name is Gina Lundwitz and I direct the Domestic Violence Clinic at UT Law School. And one of the things that law students do is we do parole advocacy on behalf of survivors of domestic violence. So, and are just starting to do our very first clemency packet since we have this brand new opportunity to do this. So I'm excited about doing it, and I'm learning along with you, but we have learned some things along the way. And so what I am here to talk about today are expert reports. Not every single case will need an expert report. I really loved the phrase Connie used, humanizing through fact-based storytelling. there are going to be cases, probably a lot of them, that we can tell the client's story, humanize them, explain the nexus between the offense that they are incarcerated for or the offense they were convicted of and their victimization. Most of our parole clients have killed their abusers, not all of them, but many of them have. And so we are able to show the history of abuse, that sort of thing. But there are going to be cases with facts that the average person, someone who doesn't completely understand the dynamics of abusive relationships and human trafficking, are not going to be able to make that leap between what the offense is and their victimization. And so these are the cases where it's going to be helpful to include a report from an expert explaining trauma and explaining how trauma impacts a survivor's behavior. And so as part of this project, we are hoping to put together a bank of expert reports to explain typical facts so that you don't have to get a different expert for every single case. Some of the facts are pretty routine, and put together a bank of reports that explain typical facts in a case. But sometimes we may need a more specific report for our client's behavior, something that's not run-of-the-mill or routine. Our main goal in these packets that we're going to put together for the board is to put those board members in the shoes of our client, you know, so that they think to themselves, my goodness, if all that happened, I would have done exactly the same thing in that situation. That's kind of our goal. So how do you know? I'm going to share my screen with you now, and we're going to talk about how do you know if you need an expert? These are some things to consider in thinking about whether you're going to want to have an expert in your case. We want to remember who our audience is. Our audience for this vote is the Board of Pardons and Paroles. Almost without exception, the members of the Board of Pardons and Paroles are law enforcement, have some kind of connection to law enforcement. The Board of Pardons and Paroles tends to be very victim focused. So our job is going to be to show that our clients were also victims and explain that based on that victimization and based on their trauma, that their actions were not caused because they were aggressors, but they were rooted in self-preservation. So do you have facts that make your client appear to be an aggressor, or do you have facts that make your client appear to be complicit in a crime? I want to give you an example. We had a client who was being trafficked by someone that she perceived, she would call him her boyfriend. He told her to bring a John home to their apartment where he was hiding. He came out and he had a gun, and he gave the gun to her, and he told her to hold the gun on him while he robbed the guy. So you think about that and you think, what facts about that situation are hard to understand? Well, that she was told to bring the guy home knowing he was going to be robbed. So number one, she brought the guy home. That's a fact that's hard to understand. Number two, she held the gun on the guy. You know, she could have said, you hold the gun on the guy. In your head, that's what I might be thinking. So an expert can explain her fear of her trafficker. Her expert can explain that she knew what would happen to her if she didn't comply with what he told her to do. She had been beaten so many times and was so beaten down, she knew the consequences for not obeying what he wanted her to do. So that might be a situation, you know, where you would want to use an expert report. Also, if this wasn't your client's only conviction, if they have maybe a long string of convictions or even a long string of arrests, you might want an expert to talk, to do a report, to talk through those things. And then you want to think about, do you yourself have facts that you're having trouble wrapping your mind around? I've been doing this work a long, long time, and there are still times when I have trouble with some facts and have trouble connecting the facts to the victimization. And in those situations, it might be helpful to talk to an expert and see if that might be something you want to have a report for. So what sorts of things might an expert explain? We just talked about some facts, but some things that kind of come up over and over again in this work is, why didn't she just leave the abuser or trafficker? Like, she had an opportunity. She could have gotten away. There are places to go for that. So explaining that dynamic and what is it that kept our client in that abusive relationship or trafficked relationship. Why did she help her abuser or trafficker commit the crime? You know, why did she assist? Why didn't she go to law enforcement or somebody else for help? Why didn't she go to a battered women's shelter or to a place where people who are trafficked can get help? You know, why didn't she do that? Or if she was so innocent, why did she plead guilty? Why did she take the fall for her abuser or her batterer? If she didn't do it, at that point, she was in a different facility than he was. She was apart from him. Why did she go take the fall for him? So those are some things that an expert might be helpful in sorting out. So the next thing is, who is an expert and where do I find one? That's sometimes the million-dollar question. So just like in court, experts are there to explain things that the average person might not understand. And so there are two kinds. There are academic experts. These are people who have degrees and have done research and have studied domestic violence or trafficking. Maybe they've even written about it. And typically you'll find them at universities, like the University of Texas has a lot of them over there in the School of Social Work. Also licensed therapists, you know, they have credentials and they go through a licensing process, particularly therapists who assist survivors of domestic violence. You may also, though, and these are the often overlooked experts, and I want to put a big plug in for them, and these are the experiential experts. This person may not have an MSW or a PhD, they may not have a license from the state, but they have been working in the trenches of domestic violence shelters forever, and they have assisted hundreds or thousands of survivors of domestic violence. They've heard their stories, and they too can be experts and can write reports. So that's another place you may want to look at your local domestic violence shelter. They are likely to have somebody who is an expert. The Institute on Domestic Violence and Sexual Assault at the University of Texas, that's headed up by Noelle Bush Armendariz and Margaret Bassett, are working to put together a list of experts, as well as come up with some of these generic reports that you can include if the facts line up with, you know, if the facts are more typical. All right, now let's look at, so now we've found our expert, we decided we needed an expert, we found one. What do they put in the report? Most, you know, if you have somebody who's written one before, they're going to know all of this already, but you may have somebody who hasn't. You want to make sure it includes their credentials, whether they are academic or experiential or both. You want it to really be clear about what questions they're addressing. And I'm going to give you an example. This is an expert report that was written in a case that we had in the clinic. And what happened was our client shot and killed a perpetrator of domestic violence. And she was in her car and she had her windows rolled down, and he was in his car and got out of his car and started walking back to her car, and she didn't roll up the windows. And that was a big thing in this situation. Law enforcement was really focused on, well, if you were so scared of him and he's like coming towards your car, why didn't you roll up the windows? And she took out a gun, and when he reached in the car, she shot him. And so in the expert report, it specifically says, why didn't she roll her windows up when he got out of his car and started walking toward her if she was so scared of him? Like, I'm reading straight from the expert's report. There were 3 questions that she addressed, and that was one of the questions. So I think it's a good idea to have in there exactly what it is that we're asking about. And then we want their opinion, and we want to know, is their opinion based on personal knowledge after interviewing the client, or did they not interview the client at all? Maybe they formed an opinion after looking at documentation from the case. Maybe they read the police report, you know, whatever they looked at. You want them to talk about that and explain how that opinion was formed. And then finally, we always attach the expert's vita so that they can see that this is someone who has expertise in domestic violence or trafficking. I think that's all that I had. And I believe I'm almost right on time, maybe 1 minute late. So now I'm very cheerfully going to turn it over to Allie Franklin, who is going to share with us her expertise and a call to action.
All right. Hi, everybody. I see some familiar faces. Let me do that real quick. Can y'all see my screen yet? Can you hear my screen? I mean, see my screen? Okay. Weird.
We can see it, Allie.
Okay, I didn't know if y'all heard me or not. I'm like, I don't hear anyone. Okay, thank you. All right. Let's see. All right. So I am Allison Franklin. I am a program director for CARES at Safe Alliance. We serve trafficked youth age 12 to 24. I'm also a survivor of sex trafficking, and am one of these individuals that highly benefit from this process. I was not rescued or recovered or extracted from any situation. Instead, I cycled in and out of our prison system. I have 8 felonies, and nearly all incurred while under the oppression of my trafficker. So super excited to see this process for sure. I also am a nationally recognized subject matter expert. So I do fly across the nation. I train law enforcement, prosecutors, and so on and so forth. Technical assistance for trauma-informed courts and so on. So if you want to contact me, there's my email information. Feel free to, you'll see it again at the end if you have any questions. And I really just want to dive in, since this is about trauma-informed practice and trauma in practice, really cover the role of trauma. So we know, obviously, I'm sure you're very familiar that the role of trauma can change the way that we perceive ourselves, perceive the outside world, our decision-making process, the way we communicate, our lack of trust, inability to manage our emotions, and so on. So it's a challenging experience to connect with survivors when you're representing them, and we'll be covering that here shortly. Oftentimes when I hear so much, especially in the justice system and legal process, references to their latest victimization, right? So we're just talking about whether that was that domestic violence abuser, or maybe it was that trafficking experience. But it goes way deeper than that. We know, at least in trafficking, that from my own personal experience, at least 90% of the survivors that I work with have had an experience of childhood sexual abuse. And it's not just that one childhood sexual abuse, right? It's poly-victimization. I don't know if y'all are familiar with ACEs, but just to give an example of that, I do support groups in state juvenile correctional facilities and shelters and safe homes. And I always ask this question for adults and juveniles and participate as well. One of the questions, or it's a series of questions. How many people in this room have been sexually assaulted before the age of 12? We all raise our hand, myself included. How many people have had parents with substance abuse? We all raise our hand, myself included. How many people have had a parent that was incarcerated? We all raise our hand, myself included. How many people have currently experienced some type of criminal justice involvement? We all raise our hand, myself included. And the list goes on, mental health issues, neglect, etc. So it's a series of victimizations and adverse childhood experiences, and those are important when taking these things in consideration. I'm sure y'all discovered that. But there's also that intersectionality, right? Poly-victimization, but then you have, racial trauma. We've got, gender-based violence, etc. So all these intersections definitely influence and have a role in these individuals that you're working with. So criminal history too, I share all the time that, and I think it was just mentioned, right, that there's a good chance they have multiple charges that are lingering in their history as well. So for the most part, my wheelhouse is trauma and trafficking, but I can't reiterate that enough, right? That trauma before being trafficked, the trauma while being trafficked. Oftentimes, these individuals are not getting their needs met, so they're cycling in and out of services and victimization and re-exploitation. I know there's one of my sheroes, besides 2 or 3 other ones on this call, but Kelsey, I really explored strangulation. So we're talking about buyers as well. It's not something that is often included in these reports, but I can't tell you how many times I've been strangled and hunted just by predators, right, that are out there in the streets on top of the victimization of being trafficked, right? I did a series for Kelsey, and it was 4 parts on strangulation, but only one of those was my trafficker. So we've got, multiple strangulations, multiple victimizations, poly-victimizations, and this all influences your relationship with that client and how they view you. Victim offender overlap. That's why we're having this conversation. And for me, because I was gang trafficked, and this was just a kind of a case study example, not only was I groomed to be his prostitute and property, but I was also groomed to be, and this is a term that we are trying to move away from, and that's bottom. So that means I purchased all his drugs, I sold all his drugs. Organized crime, so we were gang members, so anything to do with guns, money, cars, drugs, you name it, we did it, all the while being set up to completely insulate him from the criminal justice system. I do a lot of training on this, aspect or arena, and the truth of the matter is, though, these are the individuals that are the most victimized. I share all the time that the fact that I took on that role as the bottom was just a reflection of just how broken I had been, how much he had stripped me of my agency, that I finally gave in, and he completely owned me. So it's super important, because a lot of the individuals that you're working with, right, 90% of trafficking survivors have reported being arrested, and nearly half of those more than 9 times. And so you will see there's a lot of anxiety, right, and stress around navigating this process, especially if you've been re-victimized by our criminal justice system and let down and failed by systems, for multiple times. Also, right, a vast majority, at least that I know, they're not assessing culpability with their victimizations in mind. I think we're making some movement in that direction, but I see it all the time. It's not just adults, it's juveniles too. I've gotten clients, in my groups that were literally just present, right, in a crime, and they were the ones that took the fall. Nothing worse than having a 12-year-old cry to you and say, they didn't see me, right? They just re-victimized me. How can I be the mastermind behind this when he's in his 20s and I'm 12 and she's the one pegged as the mastermind? So this is happening. It's happening across the board. It definitely is intersectional, right, with domestic violence as well. I think the hardest part too is you probably will see individuals that have been in our juvenile justice system, and it's a direct pipeline into our adult prison system. So I'm seeing kids who are wrongfully in that place that are charged as adults on a unit, going into an adult unit, and it's just victimization upon victimization by the very institutions that are meant to be in place to help and protect them. So, let me shut the chat. Thanks, Kelsey. Just important to note, these, in effort to really exit the life, right, this is exactly what survivors need. I'm sure that many of you are familiar with those needs, but really the biggest part is that clean record. Because I have 8 felonies, it wasn't until my 9th felony, I took a drug charge for my trafficker, that I was offered any type of meaningful services, but it has created immense barriers, even to this day. Even though I've been doing this work for nearly a decade, and I have very powerful spheres of influence, when I moved up to Austin to do legislation and lobby, no one would rent to me, right? Nobody would rent to me because of my record. I've had my car insurance been denied because I was considered high risk. My APR rates have been higher because I was considered high risk. Had total 4.0 GPA at a university and denied a program of choice because of my criminal history. I couldn't get a license in that field. So just numerous barriers. And this is really the point of that, right? Just as Elizabeth had said, is just that opportunity for a fresh start. Super important. And the worst part about it is so many of the clients that I work with don't have the support systems that I have. And those individuals potentially could be tethered to a life of commercial sex work and a lifetime of abuse if that criminal record is a barrier as far as employment, etc. So super important. I mean, we know there's promising practices. Part of that's that criminal justice reform and reentry services. And not all of these are appropriate to your work here, but definitely that trauma-informed care and just creating alternatives, right, for individuals to re-enter into society successfully and healthily. This is really critical too, because of the trauma that individuals have experienced. One, this process, I mean, even my own, like I have a lot of skills, I've got a lot of support systems. Even this process for my own felonies seems daunting to me, right? Because I'm having to relive all those experiences, revisit all that stigma and shame, and a lot of anger too, right? That you've been let down by the systems that are, as I said, meant to help and protect you. Also with that trauma, right? Most of the trauma that I see individuals that I work with, it's come from relationships. And the way to reverse that is through relationships. It's creating that healthy and safe connection with an individual. And that is really a core component of trauma-informed care. And I'm sorry if you hear my 100-pound dog crying, he's whining. So I think, you know, a lot of clients might experience a lot of shame in this process. And so, I mean, just be diligent, right, about staying connected with that client, following up with them, continuous engagement. trust takes a lot of time and effort, and it's something that you really have to be invested in an effort to create that better client relationship, right? Especially those that have experienced trauma. So what to do? Definitely validate. They might not necessarily be titled as a victim unless they're already in our criminal justice system. Currently, you could be working with survivors. I'm a survivor. Victim's more of a term from a service provider standpoint, legal language. So this could be also, you know, someone that's well into their healing process. Like I said, I've been out of this life 10 years. This is the first opportunity that I have to hopefully get a fresh start. So offer specific help, lift them up, encourage them, right? And for those that might not be so stable, make sure you got a safety plan in place. Is there questions? Nope. Okay. So this is super important, especially if you're working with individuals that might currently be in a place where they don't necessarily self-identify, or maybe they're on that cusp, right? For me, it's very fluid. Like, that's not my pimp. That's my husband. He loves me. 2 weeks later, that is my pimp. Let's do something about it. 2 weeks later, I love him. I miss him. So it's just a good idea not to badmouth the abuser. They might still have emotions attached to that. No empty promises. Please don't make it about you. So often I've had those experiences, even, you know, on the other side of this. So be transparent, be honest about what you can and can't do. Don't overpromise. I feel transparency is key. Predictability is key. Just being forthcoming about that process and be real about the bounds of that process. Trauma informed core principles, right? That safety and stability, cultural humility and responsiveness, understanding that role of trauma, and not just the trauma that is on paper and that you're documenting, but all the intersectionality trauma as well. I won't go into all those because I know I'm running out of time. But these are really the tenets. Just don't do any harm, respect and kindness, and prioritizing their safety, and not just necessarily safety from their trafficker, but also with the consideration that this is very triggering process, right? So this can be, you know, a safety concern for those individuals if they don't have a safety plan in place. Make sure you're totally aware of your nonverbal communication. For me, my survival depended on being able to read people in my environment, literally. So just be authentic in those relationships. I can definitely tell when someone is just not being sincere. So super important as well. And I guess I'll open it for any kind of questions or anything that anyone has. I think I went a few minutes over. Sorry about that.
I don't see any questions in the Q&A, but thank you everybody for staying on, for joining us. I just want to redirect you to the Lone Star Justice Alliance page where we've hosted the attorney application. We invite you all to become pro bono attorneys on the Survivors Project, and we thank you so much for joining us. Have a good Friday afternoon, everybody.
Bye.